Our last witness is Stephen Halbrook. He's practiced law for over 30 years. He's authored, edited 7 books and dozens of articles related to the right to bear arms. He was also the author of an amicus brief in a recent Second Amendment case before the Supreme Court, District of Columbia versus Heller, submitted on behalf of Vice President Cheney and 250 members of the House of Representatives. Mr. Halbrook is known in my state, a state which actually has, as I mentioned yesterday, has no gun laws, except during hunting season. And then we have certain restrictions if you're going to hunt on the State House lawn. I also noted the fact that I own numerous weapons, and I'm almost tempted. Well, I'll tell the story about Director Free and myself target shooting in my backyard in Vermont later on. Go ahead, Mr. Halbrook.
Thank you, Mr. Chairman. Good morning, Senator Lay and Senator Specter. It's a real pleasure to be here. I did file the amicus brief on behalf not only of 250 representatives, but also 55 senators, including majority of members of this committee, in the Heller case. Heller, as you know, held that the Second Amendment means what it says, the right of the people to keep and bear arms, means that individuals have that right. I'm author of the book, The Founders' Second Amendment, and numerous other publications. I've done a lot of litigation on this subject in the Supreme Court. I'm outside counsel for the NRA. I'm not representing them here today. This is an issue that we have an explicit constitutional guarantee. We live in an age when people invent rights and they seem to be implicit in the Constitution. And I like Senator Leahy's the right to spoil grandchildren as an implicit constitutional right. It's a lot more innocuous than other ones that might be invented, and fully support that concept. As you know, Mr. Holder filed, or rather joined in an amicus brief in the Heller case, denying that the Second Amendment protects any individual right and seeking to uphold the total ban on handguns by D.C. residents. My background, by the way, I've appeared before this committee a number of times going back to the 1982 subcommittee on the Constitution hearing and report, which was entitled The Right to Keep and Bear Arms. Serious concerns, I think, are raised about Mr. Holder's position. Throughout his career, he's denied that the Second Amendment basically means anything in regard to private citizens, and he's advocated basically the criminalization of what many people consider to be their constitutional rights. And I'm talking about, for example, the advocacy of making it a 5-year felony to possess an unregistered firearm in the District of Columbia. That was when he was U.S. Attorney. And there's been many other draconian proposals that he's set forth. I listened carefully yesterday to Mr. Holder's testimony, in particular the question that if the Supreme Court reconsidered the issue of the meaning of the Second Amendment, whether it was recognized individual rights, it does refer to the right of the people after all, or some kind of elusive collective right that doesn't really protect anybody. And if the Supreme Court revisits that issue, what position would you take? And Mr. Holder responded that first it would depend on the facts, even though facts really don't matter in the interpretation of a constitutional provision. And he did say that stare decisis is one consideration that would be taken into account. I think given that he has supported the so-called collective rights view for his career, it's most likely that he would indeed support a reconsideration of the meaning of the Second Amendment. And in addition to that, Mr. Holder, based on his career-long proposals for draconian firearm bans, would be likely to say that nothing really violates the Heller decision if it indeed stands the test of time. I'm not going to get into any policy questions, but I did take note yesterday that he advocated the reenactment of the so-called assault weapon ban as a permanent fixture. The Heller decision did talk about firearms that are commonly possessed by law-abiding people for lawful purposes as being protected by the Second Amendment. It might depend on what a person arbitrarily chooses to call by this pejorative term assault weapon, whether that test would be met or not. But there's a lot of meat in the Heller decision that basically says that banning commonly possessed firearms would violate the Second Amendment. He mentioned that what he called the gun show loophole must be closed, and it reminds me of his prior advocacy of a federal law that would require background checks on all private intrastate transactions involving firearms, presumably making it a felony to give a firearm to your grandchild as a gift without a federal background check, and also has advocated the registration of all firearms, that all of these background checks on private transfers would be registered with the Bureau of Alcohol, Tobacco, Firearms, and Explosives. So we would have a registration system of firearms. He was asked yesterday about proposals to ban firearm possession by individuals who are in the age group 18 to 21 years old. And that was a proposal that he supported. Mr. Holder supported H.R. 1768 back in 1999. So you would have the phenomenon of a person who's serving in the armed forces, eligible to do so, age 18, eligible to vote, serve on juries, and it would be a federal felony for them to possess a firearm. Now, the Attorney General not only prosecutes federal crimes and influences courts on the meaning of constitutional rights, the Attorney General also administers and enforces the Gun Control Act through the Bureau of Alcohol, Tobacco, Firearms, and Explosives. For his entire career, Mr. Holder has denied that individuals have any Second Amendment rights on behalf of law-abiding citizens. He has advocated that firearms must be registered, and the possession of an unregistered firearm be punished with 5 years imprisonment. The millions of Americans who exercise their Second Amendment rights rightly feel uneasy about this nomination. Much has been said about unjust prison sentences imposed on persons who possess crack cocaine, not to mention the rights of alleged terrorists held at Gitmo and other places. And we would hope for sympathy to be shown for Americans who bother no one and who merely wish to exercise their Second Amendment rights without being sent to prison because they possess a gun without the government's permission.